Calling a lawyer in the minutes following a car accident is probably not most people's first thought. Making sure they don't need emergency medical attention should be the first priority, followed by making sure their car is drivable, speaking to the police, and gathering information at the scene. But what happens next? I'm often asked how a car accident case actually works. And in this video, I'm going to lift up the hood and break down the nuts and bolts of a car accident case from beginning to end. Hi, I'm attorney Scott Poisson, an injury attorney licensed to practice law in Nevada, Arizona, New Mexico, and Florida. In almost 30 years, I've handled thousands of cases. So let's dive into today's topic. You're in an accident, the dust has settled, you're able to drive from the accident scene or someone else was able to bring you home. Once your adrenaline has calmed, you feel pain in your neck or back. The next day, you call a law office. Most of the time, you will not immediately speak to a lawyer. At my firm, potential new cases initially speak to our intake specialist. It's the intake specialist's job to get some basic information from you to determine if we can be of help. The intake specialist will want to know the type of case you're calling about. For example, is it a car accident case? Is it a premises liability case like a slip and fall at a grocery store? Is it a medical malpractice case? The intake specialist will then want to know what happened. Was it a rear-end collision? Did someone run a red light or a stop sign? Or did someone fail to yield the right-of-way? Were you injured? Do you have any pain? If no pain anywhere, we would not be able to help. There must be some pain. There must be some injury. In fact, I do not know a single lawyer that would take on a car accident case if there is not an injury. I do not know any lawyers that only handle property damage or the repair of a car. As a courtesy to our clients who are injured, we do assist with resolving property damage claims. Additionally, we only represent people who are injured by the negligence of some other person or company. If the accident was completely your fault, we would not be able to help. Assuming that you are experiencing some pain and someone else caused the accident, our intake specialist will then get one of our attorneys on the phone to gather more information and answer any questions you may have. We handle personal injury cases on a contingency fee basis. That means that you do not pay any money up front for us to help you. You do not pay us for our time while working on your case. We do not get paid unless we recover money from the other side. We also front all case costs and do not get reimbursed until the case is over. That means that we use our money, not yours, to pay for all expenses related to your case. For example, that could be charges by hospitals and doctor offices to get copies of your medical records. Most of the time, if a case settles without a lawsuit, case costs typically range from $100 to $500. Again, we front those costs. If a case requires a lawsuit, we have to pay a filing fee with the court. There would be charges for court reporters for depositions. But normally the biggest expense involved in lawsuits is for expert witnesses. If a case is in litigation, expert witnesses are required. The type and number of experts needed varies with the complexity of a case. Experts certainly would include medical doctors to explain your injuries and the impact that they have on your life. It could be one doctor or several, depending on your injuries. Other possible experts for a car accident case could include accident reconstructionists, biomechanical engineers, vocational rehab and life care planning experts, as well as economists. The bottom line is that we pay for all of these experts and litigation expenses. You do not pay anything out of pocket during the case. These expenses are reimbursed at the conclusion of the case from the money received from a settlement or verdict. We cannot begin working on your case until you sign the Contingency Fee Agreement. Our agreement is a standard agreement approved by the Nevada Bar. We try to make things as easy as possible for our clients, so this agreement can be signed on your phone via an app called DocuSign. Once that is signed, we can immediately begin working on your case. At our firm, your case is always assigned to at least 2 and usually 3 lawyers. We believe that 2 or even 3 brains is always better than 1. So your case is assigned to one of our associate attorneys along with 1 or more named partners at the firm. In addition, your case is immediately assigned to one of our case managers. A case manager is similar to a paralegal. The case manager helps gather medical records and other evidence. The case manager is always there to answer questions when the assigned attorney is not available. Since case managers are not lawyers, they are not permitted to give you legal advice though. The case manager helps file pleadings with the court. The case manager helps resolve property damage and car rental issues. The case manager will then call you to introduce herself or himself to you. During this initial call, the case manager may gather some additional information that we will need. There are some additional forms that we will need to have you sign that enable us to get things like your medical records and bills and the police report. The case manager may also arrange for our investigator to meet you at your home to take pictures of your car or gather other evidence. The case manager will notify all potential insurance companies that we represent you and try to determine what the policy limits are. The case manager will also request the police report. For any new car accident case, the most urgent areas that require attention are 1, getting your damaged car fixed or paid out if your car is totaled, and 2, making sure that your injuries are properly documented and treated. If needed, the case manager will immediately begin working with the insurance companies to get your car fixed, possibly get you a rental, or resolve a payout if your car is a total loss. I cannot emphasize enough how important it is to have a medical provider document your pains and injuries as soon as possible after an accident. Along those same lines, the ultimate goal is to get you feeling better and hopefully back to your pre-accident activities. We will immediately get you in to a healthcare provider who will properly document your injuries for the adverse insurance company and to also begin whatever treatment you require. You may be asking, well, what if I don't have health insurance or the ability to pay to see a doctor? And that's not a problem. We know healthcare providers in most specialties who regularly treat accident victims. They do not require any payment up front. They wait until the end of the case to get paid. They will provide the necessary treatment, whether it is physical therapy, diagnostic or radiological tests like x-rays and MRIs, and even perform surgery. The value of your case depends heavily on the nature of your injuries and the treatment that you receive. The more time that goes by without treatment, the easier it is for the insurance company to defend. Similarly, large gaps in treatment certainly do not help your case. Failing to follow doctor instructions or recommendations can also hurt your case. We make it easy to get your injuries documented and treated with healthcare providers that understand the importance of what is contained in medical records for an accident case. The case manager will also schedule your one-on-one strategy session with me. This strategy session is so important and it is something unique to our firm. You will have my personal, undivided attention during this session. This session is so important. It occurs shortly after you become a new client. It is equally important for both of us. I use my decades of experience handling personal injury cases to really explore the facts and issues of your case. This puts me in a better position to strategize the best way to get you the most money for your case. I begin to determine the strengths and weaknesses, if any, of your case. It allows me to orchestrate my team as to exactly how to handle your case. During this session, we will typically begin by going over the facts of your case, along with your injuries. I usually then go back in time and go over your pre-accident medical history. This is important because your pre-accident medical history can have a positive or a negative impact on your case. I want to know the good and the bad early on so that we can work on a strategy that maximizes the value of your case. After I'm finished getting the information I need from you, I then explain the process as to how your case will be handled. I finish by answering any questions that you may have. It is my belief that it is our job to educate you so that you can make educated decisions about your case. The education process begins with this important strategy session. During the next few weeks or months, the most important aspect of your case is on the medical side. It is about determining the extent of your injuries, the necessary treatment, and what impact the injuries and any limitations have on your life. So during this phase, it is critical that you show up for all of your medical appointments on time. It is important that you keep us informed about your treatment and that you notify us if you are referred out to any other medical specialist. We will be monitoring your treatment during this time. Once the doctors have a better handle on your injuries and what they will mean for you in the short and long terms, we will then engage with the insurance companies. We will present the evidence to the at-fault party's insurance company or companies. We will argue why their driver is at fault, along with the damages that the driver's negligence caused you. We will explain to the insurance company how this accident has impacted your life. At this point, the insurance company will either deny the claim, stating its driver was not at fault and/or the claimed injuries did not result from the accident, or the insurance company will make an offer. If the insurance company denies the claim, then we will explain the denial to you and go over the law and evidence applicable to your case. Ultimately, your option when there is a denial is to either drop the claim altogether or to file a lawsuit and litigate. We are there to help you make that decision that makes the most sense. If the insurance company makes an offer, 99% of the time it will be a lowball offer and not a final offer. A lowball offer means an offer that an insurance company knows that you are unlikely to accept. But they do it for 3 reasons. 1, they might as well try because maybe they get lucky and you accept because you just want to wrap things up quickly and move on. 2, the offer is just a starting point, a first offer, and they want to keep it on the low end. And 3, the real reason, they hope that a lowball offer will rain on your parade and demoralize you and cause you to set the bar lower. During this negotiation period, the goal is to find out the maximum amount that the insurance company is willing to pay. There will usually be some back and forth negotiations until A, the parties get close enough that it makes sense to resolve the case, or B, the parties remain too far apart. Keep in mind that most negotiations require compromise. In fact, a common definition of a good settlement is where both parties walk away slightly unhappy. The insurance company believes it paid too much, and the injured person believes that the insurance company did not pay enough. I'm not going to spend too much time on negotiations as that will be a topic for another day. However, it is important that everyone understands the time value of money as well as the risks inherent with litigation. What is important to understand are these key points. A settlement means the case is over. There is no more uncertainty or risk. You will get your money quickly. Time value of money means that in any analysis, you need to take into account that litigation will often take at least a year and is not unheard of for a case to take years. It may not make sense to waste all that time with the hope of getting a little more money. Besides the time value aspect, litigation can be expensive. Even if you ultimately get a verdict that is higher than the final settlement offer, you may actually end up getting less money because of the litigation expenses involved. And settlement is a guarantee. Litigation is not. With a settlement, the case is over and you know the result. You have control over whether a case is settled or not. With litigation, you are putting your case in the hands of a jury. And if there's one thing that a room full of lawyers can agree on, it's that no one can guarantee what a jury will do with a case. It's a gamble. In any event, when we get the insurance company's top settlement offer, we will explain the pros and cons of the offer, explain our recommendation, and help guide you to a decision that is in your best interest. We cannot settle your case without your permission and authorization. If the case settles without a lawsuit, the adverse insurance company will require that you sign a release. A release means that the case is over and that you understand that you can never come back asking for more money and you can never file a lawsuit over the subject incident. After settlement is reached, my office will contact the medical providers that are owed money and work on negotiating their bills lower to put more money in your pocket. After the outstanding bills or liens are resolved, we will then present you with a closing statement that shows the breakdown of the settlement funds, including the attorney's fees, case costs, payment of bills and liens, and your net result. In general, money you receive from a personal injury case is tax-free. A major exception is for any settlement money that is specifically earmarked for wage losses, and that is because you would have had to pay taxes on those wages anyway, even if you had not been in an accident. Once the release and closing statements are signed, the insurance company will issue us a check. We will then pay the outstanding bills and liens as detailed in the closing statement, and then cut your settlement check. Now let's move to litigation. So assume that the parties are unable to reach a settlement agreement, and assume that after we explain the breakdown in negotiations, as well as the law and the evidence applicable in your case, you authorize us to file a lawsuit. A lawsuit requires the formal filing of what is called a complaint in court along with the filing fee. A judge will be randomly assigned to your case. After a lawsuit is filed, it must be served upon the defendant by a process server. Understand that the at-fault driver's insurance company is not the defendant. In fact, the very fact that there is insurance is inadmissible evidence and something the jury would not be allowed to know. The defendant would be the at-fault driver and/or the owner of the vehicle. If the at-fault driver was driving as part of his or her job at the time of the accident, then the driver's employer would also likely be a defendant. Just like in the movies or on TV, a process server will actually go to the defendant's homes or places of business and give the defendants a copy of the lawsuit. Once the defendant is served with the lawsuit, the defendant will turn it over to his or her insurance company. The insurance company will hire a defense attorney to represent the defendants. In general, the insurance company will pay for the defendant's attorney fees and litigation expenses. The defendant has 20 days to file an answer or responsive pleading to the complaint. Although the defendant often requests and gets an extension of time beyond the 20 days. The defendant's answer is normally of no significance as the defendant usually just denies everything. It is just a formality that must occur for the litigation to proceed to the next phase. In Nevada, if the court does not think that the damages in the case exceed $50,000, the case will be placed in the arbitration program, which will fast-track the case in comparison to cases with potential damages that exceed $50,000. Now, the phase that occurs after the defendant's answer is filed is called discovery. Depending on the complexity of the case, most judges in Nevada will allow 6 to 18 months for discovery, but often at least 12 months. Discovery is when both sides further investigate the facts of a case. However, unlike before a lawsuit is filed, now both sides have much more powerful tools at their disposal. Both sides have the court's subpoena power. That means that they can force people to sit down under oath and answer questions in a deposition. Both sides have the power to serve subpoenas on businesses and people to obtain specific documents. Traditionally, during the discovery phase, both sides send each other written questions called interrogatories, which the parties need to answer under oath. My team will assist you with answering these questions. Requests for production are sent by each side with a list of documents that they would like. For example, in a typical car accident case, the defendant would certainly request that we produce all of your medical records that we possess. The request would also include a medical authorization for you to sign so that the defense can send a subpoena along with the signed medical authorization to any of your past and present medical providers to get your medical records so that the defense can research your complete medical history. If you are claiming wage loss from an accident, the defendant would typically request copies of your tax returns and wage statements. The defense may request employment personnel files. Simultaneously, we would also send requests for the defendant to produce various records depending on the contested issues in the case. At some point, you will likely have your deposition taken where you answer questions posed by the defense attorney under oath. You're not going to be left alone with the defense attorney. We prepare you ahead of time for the likely questions that you will be asked. We are present with you during the deposition to protect you and make sure that the questions that are asked are proper and to ensure that you are not inappropriately harassed or bullied. The general topics would be on the accident, your injuries, your pre-accident medical history, whether you claim loss of wages, and if so, the basis of your claim, the impact of your injuries on your life, and there are usually background questions such as age, education, marital history, where you lived, etc. The background questions have nothing to do with the accident, but are more for the defense attorney to evaluate you a little better. During discovery, the defense attorney will have the opportunity to choose a medical expert to review all of your medical records and examine you as well. Keep in mind, this is not an exam to help you. It is an exam for the defense expert to try to minimize your problems or to relate them to other causes besides the accident. The defense doctor, along with your treating doctors, may be deposed by both lawyers, where the doctors have to answer questions under oath as well. Depending on the complexity of the issues in the case, there could be many other experts that are hired during discovery. Some of these experts could be biomechanical experts, accident reconstructionists, vocational rehab experts, life care planning experts, and economists. Both sides may take the depositions of some or all of the other side's expert witnesses, as well as any other witnesses in the case. There are two main reasons to take a deposition. One, to find out what a witness or party knows, and two, to lock down the witness or party's testimony so that the lawyer knows what he or she would say at trial. Unlike in the movies, there are usually very few surprises involving witnesses or evidence at trial. If someone changes a story during trial, the opposing lawyer can show the jury the person's deposition testimony and argue that the person is a liar or cannot be trusted. During discovery, the parties can always re-engage and discuss settlement. There is no law that prohibits settlement negotiations at any time after a lawsuit is filed. The investigations that occur during discovery can often open people's eyes on both sides and change opinions of a case. Oftentimes after the discovery phase, the parties will agree to a mediation. A mediation is a glorified word for a settlement conference. Normally the parties will go to a mediator's office for the conference. The mediator is a neutral lawyer that the attorneys on both sides need to agree to. A lot of mediators are retired judges who've had a lot of experience handling similar cases previously and have insight on what a jury is likely to do with your case. During the mediation, the parties will usually be separated and remain apart in different rooms. Prior to the mediation, the attorneys for both sides will present the mediator with their arguments in writing, so the mediator will already know a lot about the case before the mediation even begins. The mediator will discuss the strengths and weaknesses of each side's case with the hope that the mediator can help strike a compromise. It is often good for both sides to hear how an unbiased person views all of the evidence. If the case can settle with or without mediation, the same process occurs to finalize the settlement. You would sign a settlement release and a closing statement after we attempt to reduce your bills and liens as low as possible. And then the defendant would send the settlement check. And your case is finished. Both sides would avoid the uncertainty and risks inherent with putting the case in the hands of a jury. If settlement cannot be reached, and once the discovery period is completed, the court will eventually provide a trial date. Without going into great detail about how a trial works, in a nutshell, both parties will present their witnesses and evidence, and then ultimately, a jury will be asked to render a decision. While the scope of today's topic is not going to go into great detail regarding exactly how a trial works, I do think it is important for you to understand the basic questions on a verdict form, because the verdict form actually forms the roadmap to help evaluate the settlement value of a case from the very beginning before a lawsuit is even filed. In very basic terms, the jury is asked to answer the following questions in a car accident case. 1. Was the defendant negligent? And if the answer is no, then the jury's work is over. The verdict is signed and returned to the judge. If the answer is yes, then the jury will move on to the next question. 2. Was the plaintiff also negligent? A plaintiff is the injured person who filed the lawsuit. If the answer to number 2 is no, then the jury will be instructed to skip question number 3 and move on to the damages questions. If the answer to number 2 is yes, then the jury will be instructed to go to question 3. Number 3, assign a percentage of fault to both parties, and the total must equal 100%. So, for example, the jury could find both parties 50% each. The jury could find the defendant 80% at fault and the plaintiff 20% at fault, or any other variation so long as the total equals 100%. Now you may be asking, how could a jury find the plaintiff was also negligent? Well, if there are no independent witnesses or video capturing the accident, the defendant could argue that the plaintiff was the one that ran the red light or failed to yield the right-of-way and caused the accident. A defendant could also argue that even if the defendant did something wrong, the plaintiff still could have avoided the accident if the plaintiff had been driving slower or paying better attention. If it is a he said, she said situation, the jury could conclude that both parties share some of the blame. Now, the significance of this is that the percentage of fault that is assigned to the plaintiff will reduce the plaintiff's recovery by that same percentage. So using easy math, let's say the plaintiff is found 10% at fault and the jury awards $100,000. After the jury leaves, the judge will deduct 10% from the $100,000 award and it will become $90,000. Significantly, the judge will not explain to the jury the ramification of the percentages that the jury determines. 4. What is the amount for plaintiff's reasonable and necessary medical bills in the past? Notice how the jury does not automatically have to award the exact amount of the medical bills. The jury gets to decide everything. The next question is, what is the amount for the plaintiff's reasonable and necessary medical bills in the future? Number 6, if the plaintiff claims a wage loss, the next questions will be, what are the amounts for plaintiff's past wage losses and future loss of earning capacity? The final questions are, what is the amount for plaintiff's past pain and suffering and the amount for future pain and suffering? And there you have it. The jury will have spoken. The parties can either accept the jury's decision, they can appeal, which will likely add at least another year to the process, or they can use the jury's decision in combination with a threat to appeal in order to come to their own compromise settlement amount. And that concludes this overview of a car accident case, from the beginning until the end. I hope that you have found this helpful. If so, please click subscribe below so that I can continue to provide more helpful content. And if you have any questions, or if there's a specific topic that you would like to hear more about, let me know in the comments section. And please don't forget to hit like and share with your friends and family. Thanks for watching.